But the next group of cases we're going to look at deal with statutes that were now moving into the internet age. Miller and Ferber, of course, are pre-internet age cases. Child pornography was still a pretty significant problem before the internet, but if you think about it, it had to involve Super 8 kind of movies on reels. It had to involve actual hard copy pictures that maybe could be photocopied a couple times. Later on, it could involve VHS tapes. But just as the ability to digitally reproduce perfect copies and distribute them has facilitated all kinds of incredible commerce and scholarship, and just as it's also facilitated piracy of music and movies, it's facilitated the exponential growth of the trade in what we might call legitimate pornography or lawful pornography, as well as unlawful contraband like child pornography. So now, at the kind of dawn of the internet age, there are statutes that are trying to address this. And one of the initial problems that the legislature tried to address, the Congress tried to address, is, well, what about something that might be considered virtual child pornography? What about images that are sort of just innocent images of children that then are manipulated to become sexualized? What about images that are of adults, people over the age of 18, who are made to look like children? What about images that are created entirely virtually, that as technology gets better, it look less like cartoons and more like real things? How do we deal with that kind of imagery? And it really does raise a conundrum, as you'll see in these cases. And to kind of illustrate that, and in the next case that we'll look at, there is mention of some plays and literary works and movies. So Romeo and Juliet is mentioned, and this movie Traffic is mentioned. If you've seen this movie Traffic, it's about the drug trade. If you haven't seen it, I recommend it. It's really just a compelling and kind of gripping movie about the devastating effects of the drug trade on young people and their families and communities and so on. But if you've seen it, you'll know that it depicts a teenage girl who, from sort of a relatively affluent suburban family, her father is played by Michael Douglas. This teenage girl gets caught up in the drug trade. She becomes a heroin addict. And there are a number of scenes that depict sexuality involving this teenage girl. Now, of course, the girl is played by an adult actress, so it is not an actual teenage girl in these scenes. It's an adult, but she's playing a teenage girl. Now, I'm going to show you one really brief clip from the movie. And again, there's some disturbing content in this clip. If you want to fast forward it, you can. I'm really only going to show you the very last few seconds of this scene. If you've seen the movie, you'll recognize the scene, and there's probably 5 or 6 or more seconds before it that are even a little bit more it's a little bit more obvious even what's going on than what you'll see in this clip. But you'll get the idea when you see this little bit of clip. Take a look at it or fast forward if you want, and then we'll come back to it. Okay, so you see in that scene, within the context of this film, it depicts this girl's drug dealer having sex with the girl. It's an adult actress playing a teenage girl. She's obviously trading her body for the drugs, and there's a kind of whole point that's being made in the context of the whole movie about what she's doing. So that leads us to the Ashcroft versus Free Speech Coalition case in the Supreme Court and the Child Pornography Prevention Act of 1996. Now, one of the things that statute tried to do is deal with this question of virtual child pornography. So there's a few pieces of the statute. Notice that center bullet talks about computer morphing. So this is the notion that you have a picture of a child that is modified in some way to become sexualized. That piece of this statute wasn't challenged. But you have these other provisions, and in particular you have this provision about virtual child pornography. So a visual depiction that is or that appears to be of a minor engaging in sexually explicit conduct. And one of the issues in this case is the question of whether a film like Traffic, that scene that we just saw in Traffic, would be captured by this kind of thing, and whether it should be. So the majority opinion in Ashcroft, written by Justice Kennedy, joined by Stephen Souter, Ginsburg, and Breyer, holds that the statute is unconstitutional. So the reasoning of the majority opinion is that, our society, like every society throughout history, is fascinated with the lives of the young. Our literature includes stories about the lives of the young, and that includes all parts of their lives, including their sexuality. And the court talks about Romeo and Juliet and stories such as that. The interest in Ferber is in protecting real children, and the court says there's no demonstrated connection between the production of virtual child pornography and any damaging impacts on real children. There were some arguments floating around that virtual child pornography sort of feeds people's obsession with real child pornography. The majority didn't buy that argument. There was also an argument that this virtual child pornography could actually fall into the hands of children and hurt them that way. And the majority says, well, there's lots of stuff that could fall into the hands of children and be damaging to them, but we can't ban adult speech. The law can't ban adult speech on that basis. There have to be other kinds of parental responsibility and other kinds of responsibility to deal with that. There was also an argument that the virtual images are so close to the real images that they feed the same kind of market, and the majority says, well, if they were really that good, then actually the illegal images would be driven from the market. Everybody would just use virtual. In effect, what the majority is saying, the virtual images really aren't that good. Most of them don't even really look like real children. Now remember, this is a case from the 90s. The technology has gotten significantly, the imaging technology has gotten significantly better since then. But here's what the court says then. You can't use protected speech you can't ban protected speech as a way of banning unprotected speech. That is, there is some realm that is unprotected. And if you're worried that there's a protected realm that you have to sort of set a bigger fence around, that's going to be a problem. You got to try to set the fence very specifically only around the unprotected realm. The majority also says that the part of the statute that would criminalize material that conveys the impression that it involves child pornography is unconstitutional. And here the majority says this could capture a lot of things, like simply a trailer that seems to suggest the film has sexually explicit content involving children, where the trailer itself doesn't have sexually explicit content, but it seems to convey that the movie might, but the movie in fact doesn't. And the court says that would go too far. Again, that would be kind of building a fence around the protected stuff when you need to build the fence only around the unprotected stuff, according to the majority opinion. So there are some other opinions in this case as well. Justice Thomas writes a concurrence, and Thomas says, well, okay for now. For now, Thomas says, I agree, the technology isn't really that good. If prosecutors are looking at some material with relative ease and relative consistency, they can say, well, this is a real child, this is virtual material. And so it won't impinge on the ability of prosecutors to track down real child pornographers. But Justice Thomas says, if the technology, the imaging and graphics technology gets to the point where it's hard to distinguish virtual from real, then he thinks the balance would shift and the kind of impacts of the virtual on real children would be enough to allow the statute to be upheld. And then there's a partial concurrence, partial dissent by Justice O'Connor, joined by Justice Scalia. And so O'Connor says that the statute should only be stricken down to the extent it applies to what she calls youthful adult pornography. What she means by that is things like the movie Traffic, where there's actually an adult actress playing a child. And, you know, if you're sort of any kind of reasonable person watching the movie, you know that this is a depiction by an adult actress and it's in a certain kind of context. That kind of thing, O'Connor and Scalia agree should be struck down. That kind of bar should be struck down. But the other pieces of the statute, they say, should have been upheld. And they say, you know, otherwise, O'Connor says, otherwise, this ban reflects a very compelling interest. And she buys the argument, she and Scalia buy the argument that the virtual child pornography feeds the market for real child pornography. And Scalia and O'Connor agree that the conveys the impression ban is unconstitutional. So Justice Rehnquist writes a dissent, and Rehnquist is also joined in part by Justice Scalia. And Rehnquist here says, if you look carefully at the definition in the statute, where it defines sexually explicit conduct, most of the concerns of the majority would go away. It would really only cover hardcore child pornography. It would not cover, according to Rehnquist, things like Romeo and Juliet or even a movie like Traffic. Finally, Rehnquist says that even the conveys the impression ban should be upheld because, in his view, this really goes after people who are actually pandering toward child pornographers in the child pornography market, and not to other people who might, you know, happen to see a movie or rent or buy a movie because of something they saw in a trailer. So you see some of those fault lines there, and some of the questions among members of the court, and some of the policy issues and arguments that underlie some of those questions. One of the things that I find kind of interesting and also frustrating about a case like this in the Supreme Court is that, you know, as the Supreme Court often does, I think, they're making these kind of big policy judgments about, well, how much would something like a market in virtual child pornography affect the market for real child pornography? And there isn't a whole lot of empirical evidence, if any, before the court. There isn't often a very well-developed record. I don't know that in these cases there's a very well-developed record, and I'm not even sure how you would study something like that. So there's always this kind of dynamic of how you're trying to weigh this sort of evidence at this very high level of the Supreme Court.